Hello, welcome once again to Lehto's Law. I'm Steve Lehto. I got a great email sent to me by several people regarding a story out of England and the UK. There's been a ruling regarding signatures and emails and whatnot, and it's a fascinating concept. People ask me about this, but in America, this kind of law is going to vary wildly from state to state. But here we have one from a different country, but of course, our common law comes to us from England, so a lot of things that happened there have a good parallel to what happens here. And so a UK court ruling says that email signature blocks can sign binding contracts. So, in other words, we all know what a signature is, right? We think of the old John Hancock. You take a pen and a piece of paper and you sign your name and the signature, sign your life away, right? And the question is, what happens if you sign your name in some other manner? And I remember people asking about faxes, for instance. You fax something to somebody, so if you like this, sign it and fax it back. And I had people ask me, is a fax signature legal? And by legal, I mean, is it enforceable? Because usually they want to back out of something after they fax a signature. And of course, a signature in its most broad terms is any mark you make to indicate your assent to something. And so if you're agreeing to something and you mark a piece of paper and then you fax it to somebody, that's causing a mark to be made at the other end. So yeah, in many places, that's going to be a legally binding signature, even though the actual signature the other person's looking at was created by a fax machine. If you don't know what a fax machine is, look it up. So your work email signature block can be used to form a binding and legal contract. The Manchester County Court has ruled, of course, this is in England, costing an unfortunate land seller £25,000 from what she was asking when it came to selling a piece of real estate. This all happened back in 2016, at least the dispute did, but now it just finished up in court. It's over a boat jetty and a linked plot of land near Lake Windermere. Now, one side's solicitor, which would be your legal representation, sent a reply to the other side, agreeing to a suggestion they made while negotiating a contract. The dispute was between a pair of Windermere locals. One side was called the Neocleus family, and the other one was a woman named Rees, R-E-E-S. The Neocleuses owned a jetty that could only be accessed by crossing Rees's property. They tried to get a legal right to cross the land, and she objected to it. So they went back and forth, and they finally came to an agreement that Rees would sell part of her land to the Neocleuses. Then came the lawyers, of course. A solicitor of A.W.B. Charlesworth Solicitors, on behalf of Rees, emailed an affirmative reply to the other lawyers in response to some suggested contract changes. He sent his email complete with a standard footer which has his name, job title, name of his firm, and contact details. And the email reads as follows: Dear Daniel, further to our telephone conversation, I am pleased to confirm that terms of settlement between our respective clients have been reached on the following basis. 1. Your clients will pay to my client the sum of £175,000 for the transfer of my client's jetty/boat landing plot/mooring to Mr. and Mrs. Neocleus, and the release of my client's right to pass and repass over the land used as a road in colored brown on the conveyance dated 1 June 1945 between Poole and Wooton, the release. I'd be grateful if you would acknowledge receipt of this email and confirm your agreement to the above in order that I can then advise the tribunal. Many thanks, David Tier, solicitor and director for and on behalf of AWB Charlesworth Solicitors. So in response to that, Daniel Wise of the Salter Heelis Solicitors for the Neocleus family replied and agreed. Those two emails the Neocleuses argued were a binding agreement to the contract and thus the sale of the land by their jetty, and that meant a sale price of £175,000. Now, here's the deal. Rees says that she only had agreed to sell for £200,000 and is not really sure where on earth the 175 came from, and said that she didn't agree to that. And of course, if you hire an attorney to represent you and they represent you and bind you to something, you can often get stuck with that. So in the court earlier this year, the two sides ended up arguing about whether the inclusion of a name in an email footer could count as a signature legally. So if you send me an email, and you can test this, by the way, send me an email, steve@lehtoslaw.com. If I respond, you can test that too. The response block will say Steve Lehto with a bunch of contact information beneath my name. And it's just there, okay? But I also don't send out emails making promises to people or accepting deals willy-nilly. So, Section 2.1 of the Law of Property Act of 1989 says that any contract for the sale of land can only be concluded in writing. Okay? Case law says that the writing must include both sides' signatures. Now, I can tell you right now that one of the most confusing things to non-lawyers is when they say something must be reduced to writing. Is this a writing? Is this a writing? Or can both of these be a writing? And I can tell you right now that there's case law that I've actually litigated on appeal where I argued and said several different documents created an agreement that all parties agreed to. And part of it was here, part of it was here, and part of it was here. And we all agreed to that at one point in time. And I've had a court say, you know something, if you all agreed to that at one point in time, that's an agreement. You can't later say, oh, well, this handwritten document can't possibly be part of this typed up document. Why not? They're both writings, okay? So the writing must include both sides' signatures. So it is possible then, if my thinking is correct, that I can send you a signed document. You can send me a signed document back, two separate documents, but both documents contain signatures and are part of an agreement, which is in writing. The purported signature of the solicitor on behalf of the defendant was by automatic generation of his name, occupation, role, and contact details at the foot of an email, observed His Honor Judge Pierce, sitting at Manchester Civil Justice Center. In a witness statement disputing this, the solicitor wrote, I do not believe that the parties concluded a settlement agreement. They failed to agree all terms and to condense those terms into a single document that was then signed by the parties as their representatives. But the question is, does it have to be in a single document? Because I don't see that, at least in this condensation of the law here. Simply the contract must be in writing. So the judge pondered the legal technicalities of typing one's name out in an email rather than having it included by an automatic signature block, and eventually concluded, looked at objectively, the presence of the name indicates a clear intention to associate oneself with the email, to authenticate it, or to sign it. There is, the judge continued, good reason to avoid an interpretation of what is sufficient to render a document signed for the purpose of Section 2, where that interpretation may have the effect of introducing uncertainty and or the need for extrinsic evidence to prove the necessary intent. In other words, there's no point to opening the can of worms that could let people squirm out of legal obligations by claiming they accidentally put their names to things that they said by email. The judge added the use of the words many thanks before the footer shows an intention to connect the name with the contents of the email. So the upshot of this was Reese was ordered to sell her plot of land for £175,000. And the author of this article, Gareth Corfield, wrote, be careful what you add your signature block to. So one might argue that Reese has a great malpractice claim against her solicitor for £25,000, if in fact that's what happened. But, you know, I know people right now are saying, but see, this is crazy. Well, no, it's not crazy. If you read what the guy wrote, you know, it appears that they had an agreement. And so the way you avoid this in the future is you don't send emails where you say, we accept your terms with your signature block. Don't do that. Or you can say, those terms sound good. Let's reduce it to a formal document, which we will sign, but not here. And I can tell you right now that I deal with attorneys for Ford, GM, and Chrysler all day long. Okay? I know their phone numbers at the top of my head. They call, hey, how you doing? First name basis. I know these guys. And I can tell you right now that when one of them makes me an offer and calls me with it, emails me with it, or communicates smoke signals, semaphore, however they get me the message, I can send them back an email and just say, accept. And they will go, okay, Steve Lehto accepted that. Boom, we're done. But if I don't like the offer, I wouldn't say accept and then come back later and go, oh, I thought we were going to negotiate further. No, it's accepted. We accepted your offer. So when you look at this guy's email, you have little sympathy for him. In general, I can see where somebody sending a series of emails back and forth could say, I didn't think we were done negotiating. But when you see the language that says, I am pleased to confirm that terms of settlement between our respective clients have been reached on the following basis, and it includes the language that apparently they were fighting over, and then it's signed. How could you not think that was settling your case? I mean, obviously, you're going to go into court and enter a dismissal or something to actually dismiss the case, but the parties have appeared to reach an agreement. So it's an interesting case. I don't think it's that groundbreaking, except, of course, it's new technology, relatively speaking. I know emails have been around for a little while, but remember that the common law has been around for centuries. So the idea that this is creeping into the 21st century, it's about time. After all, we're only almost a decade in. So there you go. Show note, I'll be doing a live YouTube feed, 1 o'clock on October 6th, Eastern time in the US, 1 o'clock, from 1 o'clock to 2 o'clock, approximately 1 hour. I'll be doing a live YouTube feed. If you're around, you're bored, you happen to have your computer nearby or your mobile device, please check in. It's a free-for-all for 1 hour. So that's YouTube, live feed, 1 o'clock, October 6th. Otherwise, questions or comments, talk to you later. Bye-bye.